Welcome back. The DA says it'll challenge Gauteng's Cooperative Governance MEC Lebogang Maile's decision to suspend 2 DA councillors in the Johannesburg and Tshwane councils. Maile has suspended current Tshwane Speaker Katlego Mathebe for 6 months without pay. He's also suspended former Johannesburg Council Speaker Vasco da Gama for 3 months. For more on this now, I'm joined by a constitutional law expert from the University of Cape Town, Michael Osborne, joining us via Skype tonight. Michael, a very good evening to you. Thank you for being on Nightline. So, has the MEC acted within the confines of the law?
Good evening. It's not really possible to assess that at the present time. The Code of Conduct under the Municipal Systems Act requires that before the MEC take the step that he did, or the steps that he did, he jumped through a number of procedural hoops. The first thing that he needs to be doing in this circumstance is to approach the council itself and request the council to take appropriate steps. Now, based upon the information that's come out today, it's not clear whether the MEC approached either the Johannesburg or the Tshwane councils. The idea being that it's, at the first instance, it's the obligation of the respective councils to ensure that the speaker is doing the job. Secondly, Section 14 of Schedule 1 to the Systems Act does permit the circumstance where, if the MEC believes that the council is not taking appropriate steps against a speaker who's out of line, the MEC may indeed take steps, has to set up an investigation, and in the event that that investigation uncovers misconduct on behalf of the speaker, in that circumstance, the MEC may indeed take steps. There's another requirement, though, and that is that the MEC may not take any steps until the speaker has had a chance to have his or her say. Now, which of these steps have been conducted and which haven't are not entirely clear, and I don't believe that the statements from either the DA or from the MEC that we heard today have made clear exactly what procedural hoops have been surmounted so far.
And just on that, because you were speaking about the Municipal Systems Act, I've got a portion of it open here, and I'm looking at clause 14.6, which speaks of, and this is, I quote, if the MEC is of the opinion that the councillor has breached a provision of the code, the MEC may suspend or remove the councillor. Would a failure to, as you were saying, go through the various hoops nullify that provision? So in order for that to happen, would he have had to jump through the various hoops, or can he just, on his opinion alone, act against the councillors?
The answer is that he would indeed need to jump through the procedural hoops. These are called conditions precedent. The Speaker's power to act under the provision you mentioned, item 14.6, that power is triggered only insofar as he's taken the antecedent steps that are prescribed in the schedule itself. So if the DA does go to court, as indeed it says it will, first order of business will be for the DA to argue that, irrespective of the justice or injustice of the ultimate merits, for purely procedural reasons, the MEC's step must be set aside.
So looking then at this matter, Michael, you are an expert in this field. Has this sort of legislation been tested in the past, or are we dealing with a new precedent here?
No, it has been tested. There have been quite a number of cases in which there's been controversy about a speaker allegedly wanting to hold on to the reins of power, and a situation where either the national government or the respective provinces have sought to take steps. And in a number of instances, the courts have been quite strict in demanding that before you have the situation where provincial government reaches into the boundaries of a municipality, the municipal or the national government must make sure that it dots all the I's and crosses all the T's. And that's because, in terms of the Constitution, each of the three spheres of government, national, provincial, and municipal, has its own independence. And the one sphere of government may intervene in another only if certain objective conditions are met. And here it's up to the MEC to prove that those conditions have been met.
And at a broader level then, Michael, the MEC and the DA, both in the cities of Johannesburg and in the capital, Tshwane, have been going back and forth for quite a few months now. I'm wondering about the broader legal implications of what would be an ongoing tussle between the cooperative governance MEC and councils. Legally, is it just the courts that could put all of this to bed?
Yes, ultimately it is. That's the constitutionally assigned role of the courts, where you have other branches of governments at loggerheads, or where you have a situation of an impasse created by political developments. It's precisely the courts that are called upon by the Constitution to step in and do objective justice in a way that's not inflected by political interests or considerations. And the courts have been willing and able to do that before, and one assumes they'll continue to do so.
Michael, thank you. Michael Osborne, constitutional law expert from the University of Cape Town. Thank you so much for your time tonight.